Assistant Solicitor General has explained that if a person is arrested and remanded to police custody and a writ is subsequently filed challenging the arrest and the initial remand, any further remand orders issued afterwards also need to be addressed. Even if the initial remand order is set aside, the person cannot be released until the subsequent orders are also challenged and set aside. Alright, so these are arguments that are being put forth by Advocate Raju, and over here what he speaks about is that if a person is arrested or remanded to police custody and a writ petition is subsequently filed challenging that arrest and the remand, any further remand orders issued afterwards also need to be addressed. So there you have it. Okay, I am being joined by a lawyer, and let's quickly try to understand this. Now, Neha Rastogi, the argument and the technicality that has been picked up by Advocate Raju is that the remand order, the third remand order by the Enforcement Directorate was not challenged by Arvind Kejriwal, and that disallows Arvind Kejriwal to challenge the arrest that he has made, the arrest that has been made of him by Enforcement Directorate, and not just that, he cannot even appeal for bail. Do we have Neha with us? Okay. Neha, can you hear us?
Yeah, please go ahead.
Yeah, so Neha, the argument that has been put forth by the advocate Raju, who is representing Enforcement Directorate, what he goes about saying is that Arvind Kejriwal has not raised a challenge or a plea or a writ against the third remand order. So therefore, he is not eligible to get bail or get any sort of a grant or relief from the High Court.
Right, absolutely right. This petition earlier he is already moved when he got arrested by the ED. Now he is in custody of JC. That we need to understand. Now he is in custody of JC. So they have to take a bail order for the JC, not from the ED. And this application is earlier moved when he was arrested. He was detained by the ED. Now at present his custody is with JC. So now he has to move to fresh application before the High Court regarding this for seeking a bail, and now argument is already going on in the court. Here in the High Court itself, matter is going on. So they need to move in fresh application regarding this.
Okay. So what are the ways in which Arvind Kejriwal can use legal methods to get bail? Is there a possibility that today the Delhi High Court could grant him bail?
Look, it's a complete discretion of ED only. Till the time ED says he needs the custody of the Arvind Kejriwal, so he has to impact court, or Arvind Kejriwal can't ask for the bail because of reason. It's a priority discretion of the ED itself, whether he want to keep with him his custody or not for the interrogation. So for him, ED thinks right now, like yesterday we have already seen, ED has not raised any objection regarding Sanjay Singh matter because of reason. ED thought there is no need of further interrogation. Because of that reason, he granted the bail, and now ED needs to interrogate Arvind Kejriwal. Because of that reason, he is still in ED custody. And he needs more.
Okay, stay on with me, Neha, because there's more update. Because the argument that has now been put forth by Advocate Raju is that he has characterized the current proceedings as an academic exercise, suggesting that it is essentially a bail application disguised as a writ petition aimed at circumventing the stringent provisions of Section 45 of the Prevention of Money Laundering Act. The Assistant Solicitor General has asserted that there is undeniable evidence indicating the occurrence of money laundering, citing the fact that the courts have already taken cognizance of the offence. He has emphasized that the cognizance is of the offence itself and not just the offenders involved. He has referred to the first cognizance order in the Delhi excise policy case, and he has pointed out a definitive finding that money laundering had indeed occurred. He noted that his order has not been contested and is acknowledged by all the accused parties. So Neha, what the argument that is being put forth in front of the judges is that this writ petition that has been filed by Arvind Kejriwal challenging the Enforcement Directorate's arrest of Arvind Kejriwal is in fact a bail plea.
As per my knowledge, as per my wisdom, this writ petition is not at all maintainable because he is talking about the bail. He should move accordingly application towards the court. Writ petition is not for them. And apart from that, what we are talking about, amendment of the ED's law, that is a completely different procedure. We can't merge these two issues between together. Arvind Kejriwal arresting is totally different, and accordingly, that laws and regulation of the ED is totally different.
Okay, so what is the respite that Arvind Kejriwal can hope to get from the Delhi High Court? And also, if his challenge, his writ petition was rejected by the court, what further legal recourse can he approach?
He is at par, right? We have to appreciate that thing. He is in holding constitutional post. So he has many of the other options. He can manipulate things and many things. So ED thinks at present he need to be integrated properly and he need to be custody with the ED and GC. So it means like even court will respect that fact because it's about the huge amount of the money, 100 crores, not a small amount. So till the time ED needs their integration, ED needs their statement or everything or whatever they need to do it. The court will in fact not even grant the bail. Like yesterday we have seen the ED has not put any objection regarding the bail of Sanjay Singh. So court has already granted the bail. So in the case of when the ED feel like he don't need any other further interrogation or anything, inquiry from the Arvind Kejriwal, he will not raise any objection, then court will grant the bail. So it's very early. It's not even 10 to 15 days, I think hardly 10 days or 15 days. It's very early to move in application. They need to wait for a certain time because of the reason he has already avoided 9 summons. We have to remember this. Once again he will go released from the jail, then again it's going to be difficult for ED to arrest them. Right, and apart from that, he is in a path, he can manipulate so many things. So at present, he should, ideally also, morally also, he should cooperate with the ED. He should take the part of the investigation and JC maybe he has to take care of the entire thing.
Right, so how much time does he have in which he can approach the Supreme Court if his writ petition was rejected?
He can move immediately. There is no bar for that thing. Immediately, if he want, he can move that. But from my side, from my knowledge, also experience from last experience, you can see that he's not going to grant the bail from Supreme Court also.
Okay.
Because at present, it's very initial stage. He should wait for another few days. Then only he can move for that application.
Okay. Thanks, Neha, for giving us this technical analysis on this matter.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.